Hi, I'm Anna Denton-Jones of Refreshing Law Limited, and today I want to talk about a disability-related case and a claim for failure to make reasonable adjustments. Now, in order to be found guilty of that, you need to have known about the disability. So the question becomes, what actual knowledge did you have of the disability, or what constructive knowledge did you have of the disability? So, for example, all of the facts and the information that you did have before you, should you have known that really there is a disability going on here. In this particular case, the employee was a teacher and she'd raised various grievances about things to do with her colleagues and being bullied at work. It was investigated, but rather badly. An investigation report was written, but again, it wasn't terribly good. It didn't address all the issues. And it had been passed to the chief executive, who didn't read it, certainly didn't read any of the attachments that went with it. During a meeting with the chief executive in July, the employee alludes to the fact that she's got post-traumatic stress disorder. And she tells them that this goes back to childhood events, and that whenever she has stress in her adult life, it's tended to trigger things going back to that. She wasn't referred to occupational health then. They waited until the November, after she'd been off for another number of months. At that point, occupational health say, we think this employee is depressed. We think it commenced in the September. And typical for occupational health, they say, if we can get this person back to work, resolve the grievance, then they should be fine. So the onus is on the employer to then address the grievance. By this point, the person in HR who'd written the original report's gone. There's a new person in. There's a decision to redo the investigation. They've obviously looked at it and realised what a bad job had been done, decided to try and rectify it. And it seems to be that that's triggered the employee claiming failure to make reasonable adjustments. So the original tribunal fudges the issue of knowledge completely. They mix up the July meeting with the issue around normally there needing to be 12 months that somebody's had a particular medical condition in order for them to qualify as disabled. And of course, when it gets to the Employment Appeal Tribunal, they point out that, of course, the PTSD goes back to childhood, so there's no way you can argue that it's not a long-term condition. It's clearly having an impact on her ability to do normal day-to-day activities. So they find that the employer knew about it from the point when the chief executive was told in the July. And this raises an issue that I see all the time in cases where an employee tells a line manager something about their health, and it's not that it goes in one ear and comes out the other, but the line manager perhaps doesn't have the well-honed sort of disability alarm bell system that those of us who work in HR would automatically start to think, ooh, hang on a minute, could be a disability, maybe we need to investigate that a little bit more. So they just carry on as if nothing's been said. So that raises an issue around what training perhaps we need to put in place for line managers so they can spot disabilities. And I think particularly around mental health issues, because it's becoming more and more of an issue in the workplace. In the particular case, the tribunal were quite scathing of the fact that the chief executive hadn't read that report and used it as the basis of they talked about a platform for resolving the grievance, and that they really ought to have done that in the July. And if they had read it properly at that point in time, they would have realised the defects in the report and could have gone away and done the investigation that was necessary to cure those defects at that point. So by the end of that summer, really the whole issue ought to have been resolved. Again, I think this just illustrates that employers aren't going to be able to benefit from their own mismanagement of things, and that when you have got grievances, it's so important to address them as quickly as we possibly can, because we all know that the longer these things go on, the worse the picture becomes. If you have any questions, please do email me. It's adenton@refreshinglawltd.co.uk. Thank you very much.